motion for reconsideration ni House Speaker Martin Romualdez tinawag na useless ng Korte Suprema. Bilyong-bilyong na kasta ni Romualdez para sa impeachment ni VP Sara. Iniyakan na lang ni Tamba matapos prangkahin siya ni Senator Rodante Marcoleta. Pero bago ang lahat, kung hindi pa kayo nakapag-subscribe sa channel na ito, please do subscribe para mas maging updated pa kayo sa mga susunod kong mga videos. Wala ka ng pag-asa kung unanimous ang desisyon. Ito ang payag ni Senator Rodante Marcoleta sa pagmumukha ni House Speaker Martin Romualdez matapos maghain ang Kamara ng motion for reconsideration sa pangunguna ni Martin Romualdez upang puwersahin ang Korte Suprema na ituloy ang impeachment case laban kay VP Sara. Ngunit ang naging tugon ng Supreme Court ay wala na talagang magagawa pa si Romualdez na kahit isang katerbang papel pa ang gagamitin nila ay hindi na talaga sila papatulan pa ng Supreme Court. Dahil nga naliwanagan na ang Korte Suprema na ang pinapataw ng Kamara kay VP Sara ay dahil sa mga pampulitikang ambisyon ng mga alipores ni Tamba. Ayon pa kay Romualdez, "We shall respect the decision of the court, but we will also exhaust our remedies. We are preparing a motion for reconsideration." Dahil nga sa pangyayaring ito, tila hindi lang ang Korte Suprema ang nagprangka kay Romualdez, pati na rin ang isang matapang na senador na si Senator Rodante Marcoleta. Ayon sa kanya na ang naturang motion for reconsideration na isinumite ni Romualdez ay walang kakwenta-kwenta dahil unanimous na nga ang desisyon ng Korte Suprema at wala nang mas mailalakas pa nito na makakatalo sa naging pasya ng Korte. Samantala, narito ang kabuang ulat. It ain't over till it's over. House Speaker Martin Romualdez is seeking a second look for the fourth impeachment complaint that was nullified by the Supreme Court. House Speaker Martin Romualdez is not giving up on his ambition to become Vice President without a fight. On Saturday, Romualdez confirmed that he ordered the House of Representatives to file a motion for reconsideration against the Supreme Court's ruling that declared unconstitutional the articles of impeachment against Vice President Sara Duterte. Romualdez is doing this despite the unanimous decision of the Supreme Court en banc last Friday, July 25, 2025. Granting the twin petitions challenging the constitutionality of the fourth impeachment complaint. The Supreme Court held the filing of the fourth impeachment complaint violated the one-year rule of filing impeachment cases against a single officials that the House deprived VP Sara due process. Romualdez clarified that while he respects the High Court's decision, he believes that there are few points in the decision that needs to be clarified. "We are in the process of reading the decision of the Supreme Court, but, of course, we shall respect the decision. We shall also exhaust our remedies. We also be preparing a motion for reconsideration within 15 days of our official receipt," he added. But for all intents and purposes, the impeachment case is gone, a relic of our political history, a topic for conversations on how Romualdez tried to manipulate 1987 Constitution to achieve a grand ambition to become a successor in waiting to his cousin, President Ferdinand R. Marcos Jr. The en banc decision, so beautifully written by Senior Associate Justice Marvick Leonin, thoroughly discusses every facet of the impeachment case, complete with a history of impeachment in our jurisdiction. The decision is executory upon publication on the Supreme Court website. A motion for reconsideration will not stop its coming into full force and effect. Wherefore, the Senate of the Philippines has no option but to forthwith dismiss the impeachment complaint for being null and void ab initio. Romualdez was defeated. The idea of motion for reconsideration on an en banc decision of Supreme Court is doomed. The 13 justices who voted in favor of decision, one was on official business and another on leave, are unlikely to change their minds on this landmark decision that will reinforce the guarantees of due process and prevent an impeachment to be used as a political weapon. Reading the decision was a joy because it practically upheld the arguments that we have written in our post during the last 4 months. For instance, the Supreme Court highlighted the fact that the House is a deliberative assembly, an argument we had repeatedly espoused in our post. The Supreme Court said that the House of Representatives is a deliberative assembly where each member should be allowed to represent the views of their constituents. It added that there must be a modicum of deliberation so that each member representing their constituents can be heard and thus convince others to their position. That is a point we had emphasized over and over to make the case that the fourth impeachment complaint was filed in a gross disregard of the House of Representatives' rules as a legislative body. More than that, the Supreme Court tore apart the lies and deception pieced together by Romualdez with a cooperation of Secretary General Reginald Velasco and the rest of the gang. When the Supreme Court directed the House to answer several questions into the manner the impeachment complaint came into being and the fate of the 3 previous complaints filed in December 2024 instance told us it was laying the predicate. True enough, the House of Representatives balked of being asked whether a draft of copy articles of impeachment was circulated among House members, whether the evidence was attached, and what office or committee was involved in its preparation. The House hid together a lame excuse that is involved internal processes that were beyond the ambit of the Supreme Court's inquiry. As we put in our post, only a few days before the decision was announced, the refusal of the House to provide information on these 3 points was fatal to its case. Again, we were proven right. The Supreme Court said accountability does not fall on the subject of an impeachment case but equally covers those who are seeking his/her impeachment. Any process seeking accountability of our public officers must take place within a strict framework and procedures outlined in the Constitution. The High Tribunal said those who participate in this process are as accountable to our people as those who are made subject of impeachment. It added, from the start, it was clear to us that the House of Representatives mangled its own rules when it ignored the 3 previous impeachment complaints by private citizens that were properly endorsed by House members and gave way to the 4th complaint. In its comment, the House reasoned that it introduced an intermediary step to allow Velasco to park the 3 complaints and gave him discretion on when to transmit them to the Speaker. But this was demolished by the Supreme Court. The solicitor and respondent House erred in arguing that the House is free to insert an intermediary step discretion to the Secretary General to determine when it may transmit to the Speaker, with such transmittal being the reckoning point of 10 session days. The decision said, hence, this procedural acrobatics by the House to circumvent the 1-year rule was easily exposed by the Supreme Court for what it was, a thinly discussed sleight of hand. The House said the 3 were archived on February 5, 2025 without having been referred to any committee. The Supreme Court was not fooled by this maneuver to make it appear that the 4th impeachment complaint was filed properly in accordance with the 1987 Constitution. The effect of archiving the first 3 complaint was that these were terminated and dismissed, the Supreme Court said. As such, this constitutes a constitutional bar to the filing for the 4th impeachment complaint, it said. The Supreme Court said the House may initiate another impeachment after 1-year period lapses on February 6, 2026.